this impugned order, so he can, without prejudice, he can approach them. Nothing to do with this matter at all. He's not put any money forward. He says this multiple times.
This goes, we know what will be.
No, bro, that's not the fact. 100
anyway,
over 100 crores are due, bro. The proposal has to go to the COC.
Mr. Jain, taking over a company, it's not an easy thing. For all eagles to just to whisk away a company with so much of difficulty, you would have built a company today. He wants to settle with you. You know, a bank should be positive. The whole purpose of IBC is that
after byju's, it has to, there's a particular process, it has to go under 12A to NCLT. This has to go because it's barred by delay. He gave an affidavit and undertaking to the court. He's not complied with it. Every time the matter comes up, he says, just have page 196.
Which is why I'm saying last week will examine the modified.
1 minute. Suppose there is a proposal and we will ask him to deposit the money here. If you are tentatively okay, we will ask him to deposit here and then close the chapter.
Just for 1 minute only, I just make a humble request. Just have the impugned order for a minute.
You know what it is, eh? They asked it because you know what the order is.
I have no instructions on that. What I'm saying, this appeal is barred by limitation. Nothing stops him from making that proposal and paying. It can't be an empty offer. It's been an empty offer. It's crime.
Which is why we gave an affidavit of the investor who's putting in the money.
That much we can do. They are not.
Lordship is only seeking time till Wednesday to put the offer on record with affidavits of the concerned investor also. Lordship, I have the MOU also in place, but my intention is to close this matter.
There's only that much we can do.
So Lordship will allow me to at least time till Wednesday, Lordship. Lordship will have the liberty at least that
there is only
Lordship, in the event the CRP proceeding continues, I cannot even make the offer, Lordship. My only point
is that.
But Lordship, the point is, in the event, I can just put the proposal within 1 week before this. But I'm asking time till Wednesday. I will place the offer on record. In the event the offer is not bona fide, Lordship will
stop.
Grateful, Lordship. I'm so grateful.
On your own, you see,
yes,
make so good the offer.
I'm so grateful.
Mr.
He cannot deny.
Jain will say that please ask him to do it immediately.
Grateful, Lordship.
Try your life.
Let's do it another way. Paper offer no good now. If he says 54 crores, which he said is the principal, in 1 week he brings it in, then we'll speak.
Very clear.
No, not paper, money. Lordship, the Lordship will make that clear in the order. But they have got the other sections that were related to this case using my Lord's order.
I will do my best. Lordship has given me 2 weeks. I will do my best.
We will not give you 2 weeks. Take instructions. We will take it up next Tuesday. That's it.
But kindly indicate.
Bring back it as hard cash. Not word.
Because the whole Lordship will have to.
There is a proposal by the learned counsel for the petitioner for settlement. The proposal should not be on paper, but in terms of an undertaking to deposit a particular amount on Tuesday when we are going to list the matter again. Whatever you are proposing, you say that I will deposit. You talk to them in the draft.
His undertaking. He has to deposit according to him 54 on his undertaking.
Okay, all right. And you deposit that money, then we will ask them to consider.
Yes.
Lordship, I will have it on Wednesday, Lordship, point number 1. Basically, Lordship,
The amount which you have offered, what was directed by the High Court to deposit?
Page 190. Kindly indicate that in the order.
Yes or no? Just tell answer. Just not. We will not spend the second one. Your offer before the NCLT, are you going to deposit? And then we will discuss. No instruction.
Lordship, if I am making a statement, Lordship, I have to just give me 5 minutes, Lordship.
Okay, come back. Come back.
Please, Manoj, in 49, another shocking and disturbing trend has taken place. NP9 is not equal 49, my lord. Another Pradhan in a different district was suspended. Your lordship had to issue notice and stay.
That's a different thing. But
10 other panchayat members were also suspended.
And
my lord,
was passed ex parte.
Another bench of this court has issued stay.
Wait a minute. Please, the petition.
But it's my application.
Of course, it's your application. Your application will be after petition is here.
Manoj, I'm just carrying orders where this same
deleted. Okay. Last time's order the Jesus, what is it that you are saying?
Manoj, what I'm saying is, in my case, the Pradhan was suspended and not reinstated. Similar trend has happened in another district. Pradhan suspended, your lordships had to issue notice and stay. 10 other panchayat members in a different district, Manoj, same manner suspended.
That is all right.
And I'm carrying but Manoj, all of this disturbing trend has to stop.
No.
Therefore, my lords have had Therefore, my lords, we did the last order.
Last time we have said that what you have not informed us, we have told you.
At the last order, your lord.
You are equally culpable.
That's is also
Please, my lords, I have brought everything on record. I'll answer. But on your lordship side held that the subsequent orders of appointment is illegal.
The last time we had. Each one is playing their own tricks. The last time बोला था ना. What are these letters?
My lords, I'd ask the state to
Wait a minute.
please, my lords.
24. 16 to 20. What are those two? 24 was the notification for elections, right?
Please, my
24 and 25. And 16 is what?
May I give a list of dates?
Another matter. Yes, Mr. Raju, tell us.
My lord, the order of 1st of September, which was passed by this honorable court, was based on a gross suspension, a gross misrepresentation by the other side. The misrepresentation was this, that his removal from the post of Pradhan was not because of the suspension order. The suspension order did not have anything to do with it, but it was the independent proceedings of no confidence motion, which was carried with 13 out of 14 members. So that, therefore, that has come into effect. It's removed not because of the suspension order. Suspension order has nothing to do with it. It's the independent proceedings which has resulted in his removal by no confidence motion. And then he gets the order which is passed is implement the earlier order which is.
What happened to the notice of no confidence motion?
No confidence motion was carried through.
Why was it? What for?
Under
Relating
38.
to what?
Under 30, section 30
Relating to what?
of it was, the members can decide to remove him, my lord.
What was it related to?
It was related to, if the members by 3/4 majority decide, they can.
What was it related to? You are repeatedly saying members.
I'm sorry, but
What is the inquiry about for which the no confidence was there?
no, in the inquiry, the suspension was because of the work. The no confidence different. Kindly have a look at section 38 of the Panchayat Act.
Show us
One point.
24, 125 show us. 24, 125.
Yes.
6. Sharma, where is your counter?
I'm just, my application is actually, we have actually filed this application for bringing up important date. It is 290390.
Well, suspension and no confidence are two different things, bro.
Make that good.
But they made kindly then whatever.
That's what we are saying.
First,
We are not against you. We know that we jumped the gun. We know fully well because why we are doing, because this has become a habit for bureaucrats to do that. But you convince us that 21,425 is standing on its own footing.
Yes, my lord. Kindly have a look at, my lord.
21,425.
Now that will have to be looked at earlier, my lord, at 12,824 at page 31 of the writ petition. It is page 31.
Okay, at least that you show.
12,824 was.
Paper book 30.
My lords are having.
If I may only point out, my lords, page 106.
Repetition nahi hai. Anyway, it doesn't matter. Give us the 12-8.
Yes. Annexure P4, my lords are having page 31.
12-8-24, right?
Yes. Of the writ petition, page 31.
Where is that, Court Master? Have you put it in your compilation?
Yes.
Nidhi Jaiswal's petition has it.
It is there, my lord. They have put it beyond.
12-8-24.
Well, it's at page 31 of the state's IA, in fact.
12-8-24, 96 is there. Come to page 96.
My lord, kindly have a look, my lords. It is dated 12/8/24.
Transfer किया है. Transfer से execute आ रहा है number. अच्छा, it's not translated. बात है. 96 है ना? हाँ. This is 700.
My lord, sir, may I read no
12/8/94. Correct.
No confidence motion was received against Himanshu Pradhan, Panchayat Samiti, dated 12/8/24. Today on 12/8/24, in compliance with the order number Rajkaj reference number so and so, dated 24/7/24. The chief executive.
Where are you reading this?
So no confidence motion.
Where are you reading, Mr. Raju?
Yes,
Where are you reading from?
I'm reading it page 31, my lords, of the additional document.
But Manoj, I filed an IA, I've placed it on record.
Where is it?
My lord, take my IA.
Document it has.
290336, my IA.
Rate petition, no, rate petition, page 31.
It is not before us. It's
I placed it, my lords. I placed it in an IA.
It's also in my IA, page 99, my lords. IA, page 99.
This is page 110, my lords, of my IA.
Go by what he's saying.
Please, my lords, 12/8/24.
R13, my lord.
Page 110 is 12/8/24.
99.
Yes.
चलिए.
12/8/24, subject regarding submission of voting process relating records along with voting papers on no confidence motion against Pradhan Panchayat Samiti, which changed Himanshu to the district so and so, reference so and so. Under the above subject, it is requested that in compliance with the order of so and so of the Chief Executive Officer, District Council, Bharatpur, the no confidence motion was conducted through secret ballot process on 12/8/24 by the authorized officer and sub-divisional officer so and so. All related records along with the ballot papers have been directly sent to it. In compliance with the above, the record of voting process conducted for no confidence motion.
This notice is issued, but where is that no confidence motion?
Page 100, my lords. Page 100. Today on 12/8/24, in compliance with the order of so and so, a no confidence meeting was held under chairmanship so and so. Out of total 15 members, 14 members were present in the no confidence motion meeting. After voting, 13 votes were cast.
Mr. Raju.
Yes.
Where is that letter? Who has asked for no confidence motion? On what ground they are asking for no confidence?
No confidence, no ground is required. If the members decide that no ground is required for no confidence. No ground is required for a no confidence motion.
They have signed and then sent it.
Yes.
IA 29061625, IA 290616.
And this order is 21/8.
Motion is
And the motion is at 24/1.
unexpected. 1013.
101 is the motion.
Yeah.
We think so.
Kindly.
But last time,
My notice is at page 82, my lords. Where the that is 82, my lords.
12/8. 12/8/24.
Yeah. 82 of the very compilation which I was.
Raju, 24/1.
82, my lords.
Page
Page 82, annexure R10.
1 minute. This is the problem which arises when you trust
160.
a member of the bar and then
Compilation.
proceed on the basis of 12/1/25. Page, what did you say?
82. This is an intention to move a no confidence motion.
Where do you get the date of that?
That date.
There is no date in it. When the return
It is
notice.
18/7/24, my lords.
Not that. What we are asking you is,
In this, it is not there, but it is 18/7. my lords.
what happened? What happened to this?
This notice of this no confidence motion was carried through. He was removed.
Where was it carried first?
That's the one that I read, my lord. That is at page 100.
Next page.
102. What is the date number?
Page 100.
It's on record.
13 out of 14 members, but it requires 75% of members voting. 13 out of 14 is more than 75%.
Election, is that? Election notice.
Page 20, my lord, for MA, my lords.
No, 24/1/25. What
That
Mangal Sharma
after
said.
it is removed, there has to be an election of a fresh Pradhan.
24/1/25 is the election.
Election schedule. press note of the election.
And 16 to 25 is the notification.
Notification because it's removed, so you have to appoint a new Pradhan. Therefore, that is why the notification is issued.
Repetition copy anybody has?
Please, Manoj.
Copy of the
That is
repetition?
page 24 of my MA. 25 of my MA.
Yes, no?
20 to 24 of my MA. This is not MA.
Manoj, page 170 of my I have placed the writ petition. I number.
Then, 1 minute, huh?
34.
This fact was not brought to the notice of the High Court also
It was brought, Manoj.
in the repetition.
But I did get.
Brought, Manoj, in the
You're
conduct.
saying when the no confidence was done on 12th of August 2024,
Yes.
this fact, the order included before us is what?
Manoj, may see 106 of their IA. It is brought on record.
This arises out of a subsequent petition that he files. Correct? When was the impugned order before us?
The impugned order, my lord, just
32. No, by which
8th of April 24.
But 20.
8th of April 24.
In the contempt, we are asking the date on the contempt.
Yes, Manoj. Manoj, 107 of their IA. The contempt order is
14th of August 24. That's what you are asking.
Yes, 20th
In
of.
the 14th of August 24, in the High Court, when the contempt petition was ordered, during that time, this fact was not brought to the notice that the
not at page 107. It is brought, and please see what the High Court says when it was brought on record before the High Court.
07.
107 of
It
the
is there
same IA.
when they were at page 103. It was brought to the notice of the court. In the
started
order of 12th of August.
107 is in Hindi.
Manoj, 106. Please see the
One-
second
103 of my
paragraph,
additional
third
copy.
paragraph, my lords.
This was
It
what-
starts with, it is not appropriate for this court to comment immediately on the proceedings of no
Let me
confidence
make-
motion. But despite the orders of the learned single judge, division bench of this court, if the applicant has not reinstated yet, then this is a serious matter which is not limited to the applicant
And
alone.
then
It
reinstate
is related to the dignity
fresh
of
cause
this
of
honorable
action
court.
where is removed.
This is what the court observes.
He filed a suit
By which
before the
time?
elections were to be held, did not succeed.
And my laws on the same day, the no confidence.
Same day, 12th of August 24.
Please, Manoj.
Then,
There was no question implementing because it was already removed.
when you came to, then Supreme Court's order is when?
Yes, but the
12th
Supreme
of-
Court saw.
Will you please keep quiet for some time?
I'm okay.
Supreme Court's order.
28th of February 25, my lords.
Correct. But why is it that that's your SLP?
Because it was filed earlier, therefore we could talk.
Your SLP.
Yes, ma'am.
These facts were never brought to the notice of the court. Nor where you show.
There we had challenged, but
Was the-
we had challenged,
No,
but
that's-
we can't have
no, that is
challenged
the
the
fact.
earlier order of the division bench regarding suspension, which has nothing to do with the subsequent development.
Is that SLP, is there with any one of you?
It's on record, my lords.
Yes. May I give a compilation?
SLP copy is there with anyone of
I've placed it in my IA, my lords. IA number.
May I?
in that SLP? Have you stated, if you next time if you open your, just sit down, just take your seat.
But he came and filed the petition under 32, saying that the contempt proceedings are not proceeding. Kindly I direct the High Court to proceed with the contempt proceedings. There he suppressed the fact that he was removed by no confidence motion, which was challenged by him.
Clear, that's clear.
Was dismissed.
Last time itself he said that.
He suppressed.
There is a copy of the reputation.
Yes.
Have you seen Mr. Nani, the reputation was not mentioned about
No confidence motion, nothing is mentioned.
12/8/24? I have my own doubt. 12/8/24 he might have.
Something more, he filed the suit against the notice for election. He filed the suit, he doesn't get an injunction. Suit is listed for non-prosecution. He challenges the notice itself for election. He filed the suit, the suit of the state has placed it on record. Para 6 said, I have been, there is a motion against me. Please injunct the motion. Injunction is not granted. Suit is listed for non-prosecution. And he has not disclosed anything to your lordship.
And when my lord passed,
All right, and in the specially petition, did you mention that in the specially petition that much water has passed
No,
because
we have not mentioned.
you have not mentioned?
Because that issue was different, therefore we did not.
Then it subsumes.
But it was filed.
Because that
earlier,
was only a
filed earlier,
suspension.
Therefore we did not do it.
These are all politics, because that's a suspension and immediately suspension, then there's no confidence. But you appealed, but you went to the division bench and then lost before the defendant in April 24. Then Supreme Court dismissed it on February 25. And in the meanwhile, all this has happened. August 24, did you mention about it? You would have definitely mentioned. You have a copy of
to the High Court, but we mentioned to the High Court.
You might not have. Your counsel must have missed it about the fact the subsequent. But then he has a duty to.
But my
inform
proceedings
us
are
that,
different. But his proceedings were different. I did. But that
was a copy of the writ, please.
Even if I'm not, that's in my favor. There was something which is in my favor. If I'm not said something, it doesn't make a difference.
But one more thing which I may just point out, section 37 of the Panchayat Act is for no confidence. 38(4) is for suspension on other ground. 37 is an independent action. That's all. That's all.
Look at it, it's all intended to remove an elected person. That is how we are seeing.
37 is a separate proceeding which is initiated. Supposing orders was even reinstated, no confidence can still be passed.
They are independent.
But we did not mention it's a fact in our favor.
No, 24, 125, this. No, not there. 24, 125 mentioned. That can be a simple ground itself.
It was not that the elections were held clandestinely, but
No, that's irrelevant. But does he mention it or not is the question.
he has not
24,
he has not mentioned at the time when my lords passed the order, saying it can't be done. There's a new Pradhan appointed through a regular procedure, legal procedure.
Yeah, page 5 is the repetition. Page 5 that on 12/8/24, the respondent had initiated no confidence motion against the petitioner, irrespective of the fact the content petition is so and so. That's it. 24 initiated, he says.
That's all.
He says initiated, but that very day,
on thereafter.
that very day.
This is an application filed by the state for additional document. Kindly come to item number 12 at page 5. 290,390. For additional document, so what is about this? I'm only pointing out for convenience of the court.
Page.
Page 5.
Come to item number 12.
Yeah, more or less now it's clear.
There is something more because the state has placed a copy of the suit on record which is filed challenging this notice for no confidence.
No confidence. That got dismissed.
Item 30, 40 filed the suit is injunction is not granted, suit is dismissed for non-prosecution.
What's the date of dismissal of the suit?
The suit has been rejected, my lord.
3/4.
3rd of April 25, item number 20 at page 7.
3rd of April?
3rd of April 25. Suit is dismissed for non-prosecution. No injunction is granted for holding up the election or no confidence motion.
April 25.
Because the vacancy arises.
One moment. No see notice. 12/20/25. 12/20/25 notice. And then it was passed on the same day.
Yes, followed and then.
No, it will.
And then he files a suit.
The election is held on 24th of January.
24th January notice and 16th.
That is declared vacancy.
Okay, what is the date of the repetition? Repetition filed on the
For the expedition is filed on
14/8/25.
14/8/25.
14/8/20.
And these facts are all being
And our judgment, our order is?
1st September. 1st September.
That's all.
He concealed, followed everything.
Just tell us.
Please, Manoj. If I may just point out my laws, because I put the document order.
Tell us. Simple question to you.
Please, Manoj.
That you filed your repetition on 14th of August.
Please, Manoj.
In this repetition, there is no reference to what happened. You mention on the same day, no confidence taken, passed on the same day. You mention that it is taken, you suppress that it is passed. You file a suit, suit is dismissed. Election notification issued on 24th January, and elections were held on 16th of February.
Please, my lord.
Not a word about any of these.
My lord,
Why?
I'll answer, my lord. My lord, insofar as a writ petition is concerned, we mentioned about the proceedings to carry out no confidence. We attached the no confidence motion also passed. My lord, at page 170, I have attached it. So it is not that I've only mentioned it.
Where is this?
My lord, 170 of my IA, my lord, I've also filed an IA for addition. I filed an IA for additional
In
documents.
your writ petition, you show us.
And I've placed my writ petition, my lords, in that.
Go into the writ petition.
In
You have
the
the
writ
copy of your writ petition, show us for the pages of
What
your
was the index of the writ petition? If my lords would see serial number 14 of the index of the writ petition.
confidence motion, 31.
Do not put the document. That's something to say over. 31.
You enclose the order.
I enclose the order, my lords.
But then why did you not state in your statement?
Please, my lords.
Your list of dates. You know what the practice of the court is.
Please, my lords.
We read only the list of
I
dates.
bow down to that, my lord.
We don't look into the. It's even more egregious.
Please, my lord.
Even more egregious, because when you put a document and don't mention about it,
Subsequent.
you know what it is.
Please.
You're an advocate on record.
Please, my lords.
Then you know that list of dates.
My lords, I was not
only
at that
affirmed in
time.
an affidavit.
Please, my lords, I was not at the advocate record at that time. I'm here in the name. But I understand what's falling
So
for.
therefore, you put a document. You don't mention about the document in the list of dates,
Please, my lords.
and then now want to rely on that document. That is even more serious.
Please, my lords.
Then tell us.
My lords, the writ.
So you virtually you have not improved the case. In fact, it's more serious than what it was by putting the document and not stating it. Why have you not mentioned about the subsequent elections? Why have you not mentioned about your suit?
Please, my lord. My lords, insofar, I'll answer insofar as the suit first. My lord, we filed a suit not challenging the no confidence motion. We filed a suit when a notice to conduct the no confidence was filed. The suit became infructuous because they then passed the no confidence motion. So we abandoned the suit. My lord, so in that respect, my lord, therefore we didn't take steps. The steps were taken to restore the suit, but I have to amend. So therefore I abandoned the suit.
Now, they have a point. Okay, then
Please, my lord. My lord,
the elections.
my lord, insofar as the elections are concerned, my lord, my writ petition was filed, my lord, solely praying that the contempt petition be heard, since the contempt petition was not being heard.
Why did you not mention about the fact that the
My lords,
elections
we are lacking there, my lords. I bow down to my lords. We are lacking. We mentioned insofar as the no confidence motion, insofar as the elections, my lords, we didn't place those documents.
But there is something very serious now. In the suit is filed only to stop the no confidence. My friend said, no, it was nothing to do with I, we gave it up.
No, that is before, he says. The suit is before no confidence motion.
No, my lord, suit is after challenging the process of already.
Process.
Kindly see, my lord, we said, just have a look at it.
It was filed before or after 12th of August?
It is filed, my lord.
After.
Was 14th of August. 14th of August.
6th of August 24, the suit is filed.
Okay.
Because 12th of August is the notice.
So therefore before it. So therefore 6th of August.
My lord, kindly just note one more page.
Understand. He is right only to that extent of filing the suit, seeking injunction of the notice of to no confidence, but then it went on. So they didn't get an interim order.
Yes.
So therefore the no confidence has gone on, and therefore the suit has become infructuous.
If I have restoration also. Lord,
File a restoration.
Lord, kindly see, he has filed a suit for the application for this. No, something more, Lord. If you file this petition.
Anyway, we are going to recall that order. It's not as simple as that. It's going to impose extraordinary costs on you.
Lords, I bow down, requesting not to impose costs. All I'm saying is, my lords, that insofar as the suspension was concerned, that entire proceedings becomes illegal while a stay is operating, my lords.
Breached our trust. That's the worst part of it.
My lords, the entire act of carrying out the no confidence is overreaching the orders of the court while the suspension is stayed.
Well, even when the order was dictated, he never said this, anything. Word of when the order was dictated, 1st of September, he should have said this order is not possible.
No, we'll impose costs on you. There is no question.
Persuaded.
We would have otherwise also directed prosecution of him.
No, Article 32 gives the discussion
Only one part. This doesn't reflect on what happens in Maharashtra. It's Maharashtra, no?
Rajasthan.
Rajasthan also, Mr. Shivamangal Sharma. You people have also started. is throwing away elected representatives. This is one part of the story of suppression and all that. Another part of the story is just you don't respect elected people. Anyway, we passed an order in the writ petition on 1/9/2025 under the assumption that the interim order passed by the High Court on 19/3/2024 staying the suspension is affirmed by the division bench on 3/4/2024 and also by this court on 28/2024. In this view of the matter, we had directed that the petitioner must be reinstated as the sarpanch of the as the pradhan of the what is it? Sarpanch or pradhan? What was he? Sarpanch? Pradhan of the panchayat. Full stop. As Pradhan of Panchayat Samiti, Ujjain District, Sharad Bharatpur. The state as well as
I had fought an impeachment.
who are you?
The person who stood elected.
As well as the elected, subsequently elected Pradhan have filed applications for recall. Full stop. It transpires that the writ petitioner has in fact filed. Just don't read it. It transpires that the writ petitioner has in fact suppressed important developments in the writ petition. Full stop. It is now evident that a no confidence motion was taken up on 12th August 2024. Full stop. Before this application, the petitioner had filed a suit seeking injunction against the no confidence motion, which came, full stop. The suit came to be dismissed, and the petitioner has also filed an application for restoration of the suit. Full stop. Returning back to the no confidence motion, it is a fact that it was passed on the same day and passed on the same day, full stop. Subsequently, election notification was issued on 21/7/2025 and elections were in fact held on 16th February 2025. None of these facts find place in the narration of the facts and events that have transpired, the facts and events in the writ petition. Full stop. There is no doubt about the fact that the petitioner has deliberately and intentionally suppressed the necessary facts in the writ petition. In this view of the matter, we direct as under A, our judgment and order. Our order dated 1/9/2025 is hereby recalled. Okay, B. Stop. Just, Mr. You want to say something?
Not only for my particular, where your lordship said that the newly elected has filed an application report. I only filed the application for impleadment, it clears these facts on the report. It's only the state who has filed the record. And secondly,
Application for impleadment.
Now, one more thing, my lord.
secondly, not that this writ petition where your lordship said that now please to recall the order.
Already recalled.
It would be required to be rejected.
Only one thing I want to clarify, my lord. Notice was on
Recalled and the writ petition, the order is recalled and the writ petition is dismissed.
18/7/24 is the notice for intention to move the motion of no confidence, and the motion is moved on 12/8/24, not on the same day. That correction.
18/7 is that?
18/7 is the notice, and 12/8/24 is the
18/7,
actual passing to the no confidence motion.
18/7 and no motion for no confidence was moved on 18/7. It was passed on 12/8/2024. arguable B में करिए, in view of the fact that the petitioner has suppressed the material facts, we impose a cost of 10 lakhs on the petition. The amount shall be deposited within a period of 8 weeks. Is there any fund for the state or the district?
Manoj, may impose a lesser cost, Manoj.
Why very lesser cost? For what reason you tell us?
Since we placed no confidence on record, we were only aggrieved by the.
What you have done?
We moved the court, Manoj, seeking that the
Deliberate
proceed. That's all.
Date may be fixed for compliance.
My lords had indicated by the last order that the subsequent actions were illegal, my lords. And so far as that, my lords,
In a period of 1 month from today.
Grateful.
Be careful, be very, very careful. It will have an implication on you. Or I am more concerned about lawyers. I am not concerned about what happens in politics.
Please, sir.
My registry,
Your house is this, your house is not the client. Remember that.
Please.
my registry to report compliance about deposit.
Okay, Mr. We'll do that. We have corrected our order.
Grateful, Manoj.
Lords, I may only request my
Thank you for telling
to
us.
reduce the cost, my lords.
Thank you for telling us, or else you would have committed a serious mistake.
Grateful.
On experiences.
Acting on our part, my lord, but sending a lordship can cite a petition without telling the fact of the state.
No, but you are not there.
The state falls on.
It was ex parte. It was ex parte.
But it is, why should we do it?
If in the SLP, if you had indicated that elections, everything, no conflicts are over, matter would have ended there.
Please, sir.
It
It
happens.
was lying in defect.
Lords, may I persuade my lords to reduce the cost? That's my only last submission, my lords, to some extent.
Not worth it. For what reason? For what reason?
But my lords, we moved it bona fide. We placed on record the no
You
confidence.
only know that he would have done what was advised by lawyers to him. He would not have had his own mind. But then, what to do? That
But since even in the SLP it was not mentioned, in our petition it was not mentioned. It was not mentioned on both. I'm only persuading my lords. My lords, I leave it to my lords.
8 lakhs, 8 lakhs.
The so-called misrepresentation was in my favor. If it actually not a misrepresentation as such.
Be careful, very careful.
My lords, I was not there at the relevant time, my lords. I've only come in the MA.
Not the thing, it's a lesson for all of us.
Please, my lords.
Not only you, for us also.
Please. Oblige, my
We
lords.
sometimes get carried away.
Yes.
Yes.
Wait, please, Your Lordships. Lord, item 51.
You
Lord,
have
the
to go
High
to
Court.
cat.
Lords,
You have come to the lion.
yes, Lords. Lord, the High Court has treated the petitioner, my Lord, as an employee.
Service matter, how can you? Service
Not
matter,
only
you
one
can't
point
do that.
is-
That's what is right, you approach the cat.
Not only one thing, not he's a student. Not he comes from an agricultural.
Wherever.
He's a first-time graduate. First-time
Not about the
graduate.
student, it's about the lawyer who advises him.
Lord, the problem is, Lord, if he's a student, CAT has no
You advise
jurisdiction.
him to go to High Court just because he's a student.
Lord, because if he's a student, Lord, CAT has no jurisdiction. Lord, that is only dichotomy, Lord, I humbly place before your Lordships. Lord,
These are the notified. This relating to the recruitment and all that is notified.
Lord, recruitment, if I were recruited directly only to the post, Lord, please see, Lord, my appointment
Recruitment
order.
is what you're challenging.
Lord, I am challenging refusal, my Lord, to not withdraw my resignation. Lord, what happens is he sends a resignation. Lord, he sends a resignation, my Lord.
That's me a resident. Oh? PGR.
Lord, he sends a I'm sorry, Lord. He sends a resignation, Lord, at 1 a.m. Lord, he's under emotional distress. Lord, I would say it's a moment of imprudence.
So the matter.
He sent
So
the
don't tell us
facts.
about the merit. Tell us about the.
Yes, Lord, the facts are.
What is he appointed as?
I'm sorry, Lord. In 2022, Lord, he gets admission in DM Intensive Care Super Specialty course. As part of the course, Lord, he is required to work as a senior resident, Lord, in PGIMR. Now, Lord, in 2024, Lord, in the aftermath of the RG car incident, Lord, there was some protest, etc. Lord, he was under distress. Lord, he sends a resignation, my Lord, on 15th of October. Lord, on 5th.
Employee, you are under the employment.
Lord, I have two hats. Lord, on one hat, Lord, I am a student under super specialty course. Because I am a student, I am also required to work as a senior resident. Now, what happens, Lord?
I'm making these kind of an argument where the tribunal said, when the High Court said, go to the High Court tribunal and then have your matter there.
Not only one humble
Here
submission.
you would have put an end to this controversy of your
Yes,
client.
Lords,
right?
but he withdraws his resignation in 8 hours. Not he sends the
It's again
resignation.
merits of the matter.
Not on 1 a.m. he
High Court
sends
has
the
not
resignation.
examined your case on merits.
Yes, but only one submission. Your lordships, my lord, and Konkan Railway Corporation, my lord, in 2024 have said if a resignation is withdrawn before acceptance, it loses, my lord, its validity. Your lordships have said that.
This
Not
is how the advice subverts the relief.
Not
I'm
I
telling you relief was.
Even while dismissing a consumer case against me, there are 3 liabilities that are imposed on me. But I must bring to your lordship's notice there's a delay of 355 days because there was a matter pending in Allahabad High Court. The 3 liabilities that are imposed on me for a period of
Anything, Mr. Ranjan. This is just that interest. We know that liability to have the stamp duty and other thing is of the purchaser, but asking him to pay the interest and
because when
also 1 lakh of compensation. Hardly anything.
I agree. What happens is now for 10 years, this 8 lakhs rightly entitled, claimed by me, no interest, no problem. 1 lakh litigation costs I have to pay when his case is dismissed. Stamp duty, if he had paid to me, interest could have been paid. But what was given to me was stamp papers. I kept the stamp papers with me. I returned the stamp papers. If I had got the money, I would have had the advantage of money. So to the extent of my losing interest for 10 years, it's all right. I suffer that. But 1 lakh costs plus stamp duty. There are several cases like this. This will now become a precedent.
Shall we admit it and stay, or just remove that 1 lakh so that you can at least get the money and be done with it? Is justified that 1 lakh is unnecessary.
No, my lord. Actually, this issue, the flat in question, is also part of a larger issue, which
You want us to examine it, admit and stay, or you just take instructions? If you
there are execution petitions which are almost nearing completion. There are execution proceedings against.
And my lord, only thing is this 1 lakh, series of matters.
We'll just remove that 1 lakh and dismiss it. Right?
Very well.
It should be the best of interest.
Well, actually, my lords,
this appeal is
if you see the prejudice caused to us, the non-registration is entirely owing to their default.
Yeah.
He's concealed the fact of execution proceedings being pending. For 1 year, he expresses before the NCDRC that he's going to register the flat. And just when the question of stamp duty arises,
shall we issue notice?
No, my lord.
You don't want to take away your right to argue. You will take instructions.
No, my lord, my only submission is that this.
The senior counsel with respect to the imposition of interest and compensation. However, in the facts and circumstances,
here, we feel that the exercise of...
we didn't realize it's already nearing 2.
Yeah.
Yes.
Sorry, Manoj, here it's a fresh matter. And here, Manoj, our view is that the High Court...
You can't be impleaded.
No, the High Court, I am seeking impleadment. The High Court has interfered under 226, 227, which according to us does not appear to be justified because our lordships have taken a view that looks short that in an arbitration proceeding where the Arbitration Act is a complete code, it has to be, if there is some blatant perversity on the face of the record or some very, very narrow exceptional circumstance where you exercise jurisdiction. That's one. And number two, according to us, it's also required to be a justice-oriented provision, Article 226, 227. Not in this kind of a manner where you allow someone to defeat an arbitration. Now, let me just give you a few. I'm sorry?
A bit of a problematic, Mr. Diwan. You know,
No, but here
you still need to tie up those loose ends.
I'll tie them up right away. No, because the arbitrator has done it in my favor. Look at the arbitrator's award. Look at the arbitrator's interim order. The arbitrator has passed a very well-reasoned interlocutory order, which is at page 398. Please have a look at it. He has given a whole range of reasons as to why.
Boxer Kings now goes to further opens up. So therefore, anybody anywhere says that implead him.
Yeah.
And then the arbitrator ropes them in.
But look at let me just tell you the fact.
You're saying he could rope them in rightly, he could rope them in wrongly.
Correct.
But against that order,
right?
What's the remedy? 220.
No, can I just respond to that? According to us, from an interlocutory order of impleadment, ordinarily under the Arbitration Act, there is no remedy. That's my first point. My second point is that assuming that particular order of the arbitral tribunal is ex facie perverse, or is so completely malafide that it is driven with some complete stranger to a proceeding, etc., is brought in to saddle, then of course 226, 227 deserves to be exercised. But it's a very, very, very narrow case which your lordships have so laid out that look, there may be certain exceptional circumstances. Here we have a 98-page. Yes. Now please see the arbitrator's well-reasoned order, which is at page 398, P12. P12.
398.
Yes. May I take you straight away to the reasoning? It begins at 398, P12. Now should I give some background facts or? Not necessary. Not necessary. All right. Your lordships have 398? You may just note the date of this is 20th January 25. I am requesting the court to go directly to para 26. I'll just place from para 26 at page 409 onwards.
And was who were heard? Who all were heard? R9 was heard.
Yes, was heard. Naturally. You were heard.
So far as R1 is concerned?
R1 before your lordships here today? Yeah, they are heard because they are just the proposed respondent.
They also
page 398.
They also came and opposed it.
Yes, of course, they opposed.
They had the opportunity.
Yeah, they had an opportunity. That means your lordship will see appearances are marked at page 398. Correct? Now may I take you to play para 26, please, at page 409. I'll just place these a few paragraphs here. Whether those rights are against respondent number 8 as developer, promoter or otherwise, as owner, possessor, it is not material. The fact remains that the claimant has a substantial interest in the subject property. That's myself, the claimant. Of the proposed respondent was fully aware. Why? Because they had issued a public notice. We had responded to the public notice and said, look, we have a claim and we have agreements and we have an interest in this property. Hence, this case, the provisions of the second part of Section 40 of the Transfer of Property Act can be invoked. According to this section, where a third party is entitled to the benefit of an obligation arising out of a contract and annexed to the ownership of immovable property, but not amounting to an interest therein or easement thereon, such right or obligation may be enforced.
That's wrong, Mr. That's wrong for the prima facie view.
This reasoning of the judge.
Wrong for the reason.
Yeah.
The scope of inquiry for him is not TP Act. The scope of inquiry for him is section arbitration, whether he's part of the agreement or.
So I'll just answer now. Then that's why I said let me give you background, but let me read the judgment because there are a series of orders. Now just see para 27. The present case is in view of the agreement of 25th February 2017, executed between the claimants and respondents. Certain obligations are annexed to the ownership of the subject property and created on account of conveyance deed executed by respondent number 8 and proposed respondent. The claimant is entitled to enforce these obligations against the proposed respondent, who is a transferee with notice, as rightly submitted by the learned counsel for the claimant. Section 40 of the Transfer of Property Act is divorced Section 100, which speaks of a charge and the mandate of registration. Thus, prima facie, it appears that by virtue of Section 40, the claimant is entitled to enforce its claim against the proposed respondent, being a transferee of property which is subject matter of an arbitration proceeding and which purchase is with due knowledge and in respect to the property. Furthermore, then they go on to section 91. Now look at para 37, please. 31, please. 31. As rightly submitted by learned counsel for the claimant, the Articles of Agreement of 25th February 2017 needs to be interpreted in a manner that would give it a sense of efficacy and not aid respondent number 1 or respondent number 8 or now proposed respondent to avoid the liability accepted under the agreement by keeping on creating third-party rights interests. If the proposed respondent is not impleaded at this stage, it would virtually give the proposed respondent a free pass to deal with the said property and further create third-party rights, thereby effectively virtually defeating the claim of the claimant. Moreover, the present case, the claimant's claims are not merely monetary claims against the other respondents as contended by the proposed respondent, but the claimant has also sought enforcement of a claim on the said property. In the circumstances, the transferee is a necessary party to the present proceedings so as to avoid multiplicity of proceedings. Yes. Now, okay, so now let me show you the chain. Let me show you the chain as to how he's a party. Let me show you that. Correct? Let's go to those to that. Now, first, please see my agreement. First page 152. 152, annexure P1.
Somewhere.
Sorry, annexure P1.
He's okay. P1, what is it? Just tell us without reading.
Because the names are very similar. So I want to just, this is the parent agreement. Okay, I'll just summarize it. So yeah, so page 152 is an agreement between me, your lordships may just note, Eminence Landmarks, and please note this, Gagan Platinum. Gagan Platinum, I'm just compressing the name. Under this agreement,
Gagan Platinum and
Gagan Platinum and me, right?
Eminence.
Yeah, an Eminence. This is dated 25th February 2017. What it does is it records that 25 crores are being received by Gagan Platinum for the purchase of the subject property, which is the subject land. It also recognizes that there would be a charge that I have because I'm parting with money. This money is to be used for the purposes of investment in the subject plot, and I am to get a return in terms of certain built-up area, etc. So it's most important. There is an undisputed.
Gagan Platinum is respondent number 2.
Yes, and most important for our purposes, there is an admitted arbitration clause here. That arbitration clause is clause 7 at page 163. All right, on this there's no dispute. Now it will be necessary for your lordships, if you consider it appropriate, to go to page 165. Instead of Gagan Platinum, your lordship may just note it. I'll summarize it.
So he deed of conveyance on 29th March 24 in favor of R9.
No, Manoj, I'll just tell you. Gagan Platinum, instead of Gagan Platinum, which is a partnership firm and an LLP, they are directors in a private company. So I've given you that all the partners are directors. So instead of buying through Gagan Platinum, they buy through Gagan Island Township, okay, which is a company. Gagan Island Township. Now, Gagan Island Township. So it's an alter ego. Please see that at page 165 if you don't mind. Yeah, one is annexure P2. P2. Yeah. So your lordships have P2, page 165.
Yes.
Correct? So it just shows how it's an alter ego. Gagan Platinum is left-hand side, R2, and Gagan Land Township is R9. So you'll find all the names of the partners, etc., are directors by designation. So instead of buying the land in the entity who had received 25 crores, they buy the land through a sister entity. All right.
Yes.
So so in my respectful submission, this is nothing but a smoke screen, and the arbitrator accepts this, and the arbitrator impleads Gagan Island Township as well. That order holds the field. The order impleading Gagan Island holds the field. Now what Gagan Island does is that
the argument is Gagan.
It's an alter ego, my
Land Township Private Limited.
Yes.
Is really a complete third party.
It's not at all a third party, Manoj. It's the same.
Just tell us what's the connection between?
Yes, so just go to page 165.
Mr. Diwan, please, listen to us.
Yes, yes, of course.
How are Gagan Highland Township Private Limited is linked to Gagan Platinum Spaces LLC.
Yeah. So they are So
common directors.
The partners in the LLP, are directors insofar as the company is concerned, Gagan Island, and there is a complete identity.
In fact, we'll ask them.
No, so I know there's one more step.
Perhaps you are right in arbitrating, maybe right.
So now there's one more step. I have to come to one more step. Now what Gagan Island, so it's just the same. Now Gagan Island, the arbitrator, we moved her, and the arbitral tribunal has passed an order and impleaded Gagan Island. Now what Gagan Island does is, so now we are comfortable so far.
On 29th March, they sold it to.
So there are 2-3 things which happened before that. The first is that they get their registered permission under RERA for the purpose of developing that property. So they are now the promoter. So now there's no problem because I have a charge, I have advanced money, nobody disputes the fact that 25 crores has been given, etc. Now what they do, as your lordship correctly puts to me, is the prospective purchaser, who is R1 before your lordships today, he issues a public notice. So I respond to that public notice, and I think your lordships may see that because I set out in detail that, look, you issued a public notice in the newspapers. I am responding to that public notice. So this is my situation. Now, please just have a look at that, if your lordships would. It's in volume 2. Please just have a look at page 56. Volume 2, additional documents 56.
It's all right, you're in it.
Yeah, so it's in detailed response. Now just see what so this person with full notice files. Now I have that. I want to show you that final point. Look at the conveyance in his favor. Please see that page 270, annexure P8, main paper book P8.
Yes.
Now I am raising a point because your lordship correctly put to me that, look, how do we ensure that this particular person is also bound by the arbitration? That's the prima facie view taken by the arbitrator, interdicted by the division bench under 226. Now, please look at 270. Sorry.
1 minute.
Does arbitrator in my favor?
If you are looking at it in the context of arbitration, something becomes very important here.
Yes.
In which manner R9 is anyway connected to you, not to R2 or to R1? In which manner is he connected? What kind of, is there any correspondence?
So should we say Lux Empire? By R9 you mean Lux Empire?
The last of the one which...
Yes, which is our respondent one before your lordship.
Which you seek to implead.
So which I now seek to implead and which has been disallowed.
By implication, there must exist an agreement with him. That's the requirement of law. Not what transfer of property contemplates.
Okay, so
chasing the person.
So I'll just respond straight away. I've got my answer. I'll state it. My answer is that if I have an arbitration agreement with party A and party B, who may be a complete third party, is the successor in interest of party A, the agreement binding on party A is binding on party B. Because if you don't permit that,
Cox and King say that.
Sorry? Yeah, of course it does. Because it's nothing in my respect. It's a successor in interest.
It says that our inquiry is to find out by correspondence or certain other things.
Yes.
That a subsequent third party has by implication become part
I'm saying by
agreement.
I'm saying by law. Just please see this. I'll just say by law. Supposing, keep this case aside. Supposing there's an amalgamation. I'm just saying, operation of law, companies amalgamate. There's a transferor or a transferee company. What happens in the transferee company is a successor of the transferor company. It may be a statutory amalgamation under some statute. It may be an amalgamation under the Companies Act.
No, where Cox and King says that.
No, it's binding. So it's the same entity.
So it's not the same entity.
Yes, because once you have a transferor and a transferee in an amalgamation situation, the transferee if the transferor is now dissolves, the transferor company disappears, and everything which was binding on the transferor, all rights, liabilities, obligations become binding on the transferee. It's a first principle. Yeah, and here I want to just end by saying that this Gagan Island Township.
Cox and Kings, the question.
Yes. So, below, just see page D and E of my synopsis. Page D and E of my synopsis. Yes, very well.
So, my learned friend has argued at some length. Just note these facts. Uncontroverted, admitted. Facts are completely wrong. Great respect to him. 1. Your Lordship in Cox and Kings in para 63 and 84 say that there must be two things, either consent or intention and participatory conduct to be bound. Just don't open any pages, note the point. Your Lordship will take my word for the paragraph. Para 63 and 84 is that either there must be my consent or there must be a participatory conduct intending to be bound. 1. 2. I am R1. You are forgetting. Neither R1 nor R9 is either a signatory A, nor a successor in interest, nor a participatory in any of the transaction. Fact 2. Fact 3. R9 purchased by registered sale deed is a subsequent purchaser by registered sale deed not till now challenged way back in 1st September 2017. R9 sold to me by a second conveyance deed not challenged up to date 29th March 24. Now, the fourth fact, there is no land involved. See the claim at 217, it's a money claim. Mr. Divan's client, just see 217, files a money claim against R228. The claim is against 228. Much later, he ropes in R9. I'm not concerned with 9, he was a seller to me. Well, if this is the way Cox is used, then there will be no arbitration. Your Lordship is going into the field of some Transfer of Property Act or Order Rule 110. Order 1 Rule 10, Lordship says, Lordship remembers one very interesting thing was necessary, proper, or otherwise necessary for a fuller adjudication. We are in arbitration. Now, let's just note 3 things. The findings of the High Court are very important. They say that this is not a successor, not a participant. No, just turn to those findings for a minute, please. 110, just 3 paras. Why should your Lordship interfere with these findings, please? Para 110, just turn to that. Keep my 4 uncontroverted facts in mind. 217 is a money claim. We are sale deed, subsequent purchaser, sale deed not challenged. Now come to page, para 110, page 72. Will my Lord turn to page 72? Just 2 or 3 paragraphs. We should not just brush aside the impugned order and friend, his client doesn't seem to give any weight to the impugned order. Suit?
Suppose.
Suit, your Lordship always says
the entirety of the subject matter.
If he has to file,
entirety of the subject matter.
Well, he has actually.
You are saying he should seek injunction against the respondent to the claim.
It's very interesting. My Lord Justice Narasimha will be shocked at what that's the next point. He seeks injunction against R9. Give me a minute.
In a suit?
No, in a section 9. Just allow me to just note.
What's your point?
22-12-23 files an application against this R9, not me. That 9 is dismissed on 22-3-24. Don't give me wrong dates. 22-3-24, dismissed. Then, the sale occurs to me after the dismissal of that. Nothing is pending. An appeal is filed, appeal is withdrawn on section 9. My learned friend.
That commercial court, when it dismissed the matter on 22-4-24.
Yes.
That arises out of a regular suit, is it?
No, 9.
Section 9.
Section 9. Then my learned friend, Mr. Divan's client, filed an appeal.
In that 9, who
see the order.
The respondent
to the 9 is my Lord Justice Narasimha is asked. Dismissed. Now Mr. Divan's client files an appeal.
Oh.
And he withdraws the appeal against R9. Well, I am not even born. Your Lordship is now too removed. I am made a impleader party now. This all happening against 9. How far will we stretch for section 7 of the Arbitration Act? Now just see that, but just give me a minute. Just turn to the order of section 9. Just turn to the order 254. 254. 25 minutes. Yes, this is page is 264, right? So let me focus on the page.
This one on, okay, we'll call him again.
Just 1 minute more.
What?
So what your lordship is being told is that he has a money claim. It lies against 228. He ropes in R9 in an injunction which he loses. He files an appeal, withdraws the appeal. So the injunction is final. He then impleads much later R9 for a money claim on an agreement which R9 has never signed. I hope I'm clear on this. Now, two sale deeds are there. One from an original classic fellow, name is Classic, selling to R9. Sale deed X. That sale deed is of date 2017. He's not challenging it. How can a lordship allow this kind of arbitration?
What's the argument? Because there is a charge which is rejected.
Yes, yes.
There's a charge.
The lordship will do me one favor, but just see 2 paragraphs of the impugn order. It's not fair. It's not fair on the High Court.
You mean to the High Court, all right?
100-page order. That may not be required, but 5 paragraphs of that 100 pages are very relevant. Could have been closed in 5 paragraphs. The lordship is right. Come to 110, back page 72. I want to read those 3 or 4 paragraphs only. Page 72. Page 72, 110. It's not fair on the High Court, Malas, to say that we are participators or we are subsequent. And one more test, I should remember, under 7. By or under. I'm claiming by or under you. That test is dealt with the High Court. Just see that. Nowhere, not remotely. Just getting hung. 72.
Okay, Lordship.
Just be quiet, but Lordship.
Yes, now I'll tell you, Lordship. There's a complete answer. First go to page 402.
Just note the paragraph. I'll not read. Just note the paragraph.
You're not, we just
110.
You have an issue order, the issue order.
Yes. So, Manoj, can I just answer straight away? Please go to page 402. Straight away. Page 4, paragraph 14.
402, what is that?
Yeah, this is the order of the arbitral tribunal. Your Lordships have it. Para 14. This is the order which was reversed by the High Court. Justice Chandurkar has. Yeah.
402.
402. Sorry.
What is it?
Because it starts at P12. It's in P12. P12 starts at 398.
We got it, 402.
Oh, you got it. So I'm looking at para 14. Section 8 of the Arbitration Act clearly recognizes that an arbitration can be invoked not only by a party to the arbitration agreement, but also by a party claiming through or under such party. Hence, if a party is claiming through or under a party to the arbitration agreement, can invoke the arbitration. Applying the same principle, such party can be joined in arbitration proceedings also, even in the absence of being a signatory to the party. Now go directly, please, to page 270. 270, page P8. This is his document. Can you just defeat an ongoing arbitration by creating yes, can you just the question I ask myself, the question I ask myself,
Not increase the temperature of the court.
True. The
Page?
Page 270, annexure P8. P8.
Yes.
Now the top, this gentleman is Lux Empire Realty which is the second part, which is purchasing. Gagan Island Township Private Limited, I have already shown to your Lordship, is nothing but an alter ego with the party to the arbitration agreement whom I have shown you. Now, who does Gagan Island Township Private include? Please see just before the words and. It means and includes successors and permitted assigns.
Wait a minute, what's the questions of law you formulated this?
The question of law which...
Facts we are not really impressed by.
There are 2 questions of law as I understand.
Facts we are not impressed, but if this question keeps arising from
Milord, there are 2 questions.
We'll have to think about it, that's all.
Yes, Milord, the questions...
Facts there seems to be, in facts we are not come at all with you, but the question of law is a little troublesome. What will happen in future and how it's going to be.
Because whether a party which has full knowledge purports to purchase property which is encumbered with a charge and in respect of which there's an arbitration agreement is bound by the arbitration agreement. That's the question of law. A party who... he's a successor in interest.
No difference.
He's a successor in interest.
Successor in interest is not matter. So therefore you very correctly
to seek an injunction against one. The test is
No, that's an interlocutory injunction. Look at
only Section 7 test. For an arbitration, only Section 7 test.
Yes, let's go there, man.
What extent you can take Section 7 test
Yes.
into the context of